Welcome. Brief us briefly on this item, please. Go ahead.
Yeah, good afternoon. I'm Mark Wershing of the Valley Neighborhood Project Staff Planning Department. This is an appeal of the South Valley Area Planning Commission's disapproval of an appeal of a small lot subdivision with 26 lots located at the northwest and southwest corners of Weddington Street and Hermitage Avenue in Valley Village. A related appeal of an accompanying plan approval for the subdivision was also disapproved by the South Valley Area Commission and is not appealable to the City Council. The appellant's appeal points are that the tract map is not consistent with the community plan, the project site is not suitable for the proposed density of development, the design of the subdivision or type of improvements are likely to cause serious public health problems, and an environmental impact report rather than a mitigated negative declaration should have been prepared. A fifth and sixth appeal points that may be raised are the adequacy of the parking provided and traffic impacts, and that the existing structures on the project site have historic significance and should be preserved. We think this appeal is not valid, that is not supported by the facts involving this project, and we are recommending that the decision of the South Valley Area Planning Commission to deny this appeal be upheld. Nelson Rodriguez will now discuss the issues raised by the appellants.
Good afternoon. Good afternoon, council members. The applicant has expressed 6 appeal points regarding this project. The first is having to do with the tract map not being consistent with the community plan. Staff response is that the project site is designated medium residential by the North Hollywood Valley Village Community Plan, which permits apartments, condominiums, small lot subdivisions at the density of the R3 zoning. The project's 26 single-family home small lot subdivision are permitted and are consistent with this community plan. The second appeal point has to do with the density of the project being too high for the project site. Staff response is that the 26-unit project is substantially less than the 52 units permitted by the R3 zoning and less than the 35 units allowed for the project site. In fact, the actual density is equivalent to that of the RD 1.5 zoning, about half that permitted by the R3 zone. The third appeal point is that the design of the subdivision or the type of improvements are likely to cause serious public health problems. In response to this, the appellants have not provided any facts in support of this assertion, and any impacts that might affect human health have been addressed by the environmental M&D for this project. The fourth appeal point has to do with the environmental clearance necessitating an EIR as opposed to the M&D. The mitigation negative declaration for this project was prepared with the assistance of an environmental consultant having extensive analysis of the impact along with mitigation measures to reduce the impacts to a level that is less than significant. In short, an EIR is required only if there are unmitigated significant impacts. In their appeal filing, the appellants did not provide any evidence that the M&D is inadequate. I would like to also include that because this project is in a transit priority area under Senate Bill 743, it does not have any aesthetic or parking impacts. A fifth appeal point that may be raised at the hearing is the adequacy of the parking provided and also traffic impacts. This project is providing the required parking of 52 spaces and 7 guest parking spaces. A traffic study approved by LADOT determined that there will be no significant traffic impacts on adjacent intersections, and in fact, a third-party parking study further demonstrates no traffic impacts. A sixth point that may be raised at this hearing is that the existing structures on the project site have historic significance and should be preserved. In response, an application for an historic designation for the project site was disapproved by the Cultural Heritage Commission, and the Office of Historic Resources concluded that no historically significant events took place at the project site and no persons with historic significance resided there. I would also like to include, in respect to the rent stabilization ordinance, that this project is subject to the RSO and its rent control provisions. The project site contains 9 existing rental units that will be removed. There are regulations already including specific procedures for withdrawing units from the market and for providing relocation assistance to the tenants. Staff already addressed this concern as noted on page 33 of the track map findings, itemized as number 7. This was not added as a condition of the track because there are already regulatory control measures in place to address rent stabilization as enforced by our housing department, and this project meets and abides by the RSO. For these reasons, the South Valley Area Planning Commission denied the appeal after hearing all the testimony from staff, the representatives, appellants, and community members who spoke on the matter, and because the appellants did not provide any facts or valid arguments in support of the appeal points, staff is recommending that the South Valley Area Planning Commission determination be upheld, that the environmental clearance ENV-2015-2618-MND and the accompanying mitigation monitoring program for this project be adopted, and that the appeal before you today be denied. That completes my presentation.
Thank you very much. We'll hear from the appellant and then the applicant. Rick Abrams.
Good afternoon.
Good afternoon.
There are a number of appellants, and I was wondering how you wanted to divide up the time among the appellants. I could speak for maybe about a minute or so and then turn it over to the other ones if you wanted to limit it to 5 minutes for all appellants.
Okay, there are a number of appellants. How many actual appeals? Were there a number of appellants under one appeal? City Clerk?
Yes.
City Clerk?
Yes, Councilman. Yes.
There's just one appeal?
Yes.
Okay. That's up to you, sir. You have 5 minutes. It's one appeal, so however you would like to distribute that time.
Okay, I will speak and then someone else will take over
Okay.
when I finish. This says 4:36 rather than 5 minutes.
Okay.
So if we could start
We
there.
can start.
Thank
That's
you.
fine. That's fine.
Okay,
Start at 5
my name
minutes.
is Rick Abrams. I'm speaking on behalf particularly Appellant Help. Points that I want to make I think are extremely important, haven't been mentioned yet, and that is that the developer owns only 43% of the property. Sometimes you start out not owning the property and you think that you'll be able to own all the property by the time you're seeking approval, but in this case that has not happened. This was also raised in front of the Area Planning Commission, but the city attorney told the Area Planning Commission not to pay any attention to that. Very recently, however, the developer has sued the owners of the northern third of the property, so that by the fact that the developer is suing them, trying to force them to give him the property, shows he does not own it. And when he sued them, he had to add to the public record for the court the fact that he does not only own the property, but that he was relying upon rights that he purportedly got from a non-registered LLC. Now in California, non-registered LLC cannot convey any rights to anyone because it gets no rights, it has no rights, it can't do business. It's as if it hasn't even been born yet. Therefore, the lawsuit that the developer has brought is defective. That also then makes the 1/3 of the property project in the middle not part of the development anymore because that belongs to the state. That's the Weddington Street, and you cannot just simply take part of a street and give it to the people who live on one side. Therefore, I think there's probably no discretion that this project cannot be approved because the developer doesn't own the property. I ask you to grant our appeal, and I'll turn the rest of my time over to Ms. Getz.
Thank you.
Good afternoon, council members. The DCP has determined this project has no impact, that loss of dozens of mature trees, every inch of open space, the loss of culturally significant buildings, the relinquishing of our public street that more than a dozen residents depend on for parking, bike riders, skateboarders, dog walkers, children, the elderly, and our street on a daily basis. Staff planner assigned to review this case has personal relationships with the applicants. According to her determination, it meets the requirements of the specific plan whose purpose and entire existence is neighborhood preservation. The APC has determined this proposal has no impact. Fact number one, the applicants do not own the property. Fact number two, two of the area planning commissioners that did uphold the appeal and did hear the community were the only two commissioners that had physically shown up to the site. They understood the community, the aesthetics, and the area. They were physically present to understand this. The remaining APC commissioners who voted against the proposal work for Metro and had voted because it would increase their boss's revenue, says them. None of which actually read the evidence in the record. The South Valley Planning Commission has not voted to uphold an appeal since 2006. The last appeal that was upheld was granted to developer Steve Nazemi, who is also this developer here with Urban Blocks. The facts of this case have been repeatedly submitted for 16 months. Applicants have not gotten what they wanted and are now suing two elderly property owners, forcing them to sell their mother's property, which they inherited after she passed away at 100 years old. Owner and builder of the property, Jean Lathrop, started this community in 1934 and instrumental developing this area, wanted nothing more than to keep her legacy active in the community. The Subdivision Map Act, Section 66474.61, prohibits an appeal board from approving a tract map that A, is not consistent with the applicable general and specific plans, B, the design is not consistent with the plans, C, that the site is not physically suitable for this type of development. Evidence of these findings has been made by local residents. Findings have been made by historians, organizations, teachers, professors, lawyers, students, societies, children, the elderly, the laymen, environmentalists. Any reasonable individual with a pair of eyes and a minor intelligence has made the necessary findings to prove the failure to comply with every element of the general plan. The only individuals who have found this proposal to be appropriate are the ones who intend to benefit from what they believe will be profit. Had they done the necessary research as the public has, had they actually set foot in our community, had they...
Thank you. Thank you very much. And we'll now go to the applicant. Elisa Pastor, Rebecca Duell.
Good afternoon, Chair Weezar and members of the Commission. My name is Elisa Pastor. I'm an attorney with Glazer Weil, and I'm here representing the applicant, UB Valley Village, LLC. I'm going to make this very brief. We appreciate the staff's report today. We agree with everything that they've said. I'm going to just point out a few things that I'd like to highlight. The first is that this is a multifamily zone. There are existing multifamily units in a neighborhood that is largely characterized by multifamily 2- and 3-story dwelling units. There is multifamily zoning all around the property as well as 2- and 3-story apartment buildings. There are no single-family homes. There's no open space. There is a yard in the front yard. It is not public open space. Everything here is consistent with the general plan and the specific plan. We started out at 30 units, and working with the council member's office, we have reduced it down to 26 units. The council member, or I should say one of his representatives, have spoken at all of the hearings in support of this project. We're going to be providing 2 parking spaces per unit, plus an additional 7 guest spaces. Today, there's only 1 parking space per unit and 7 on the street. So we're actually increasing the number of parking spaces on the street. I think the last thing I would just mention is that this isn't a transit priority area. It's a quite dense neighborhood. It's very close to transit. This is a very appropriate place for a small lot subdivision. You could build up to 48 units on this with a density bonus, and we're building 26. I'm happy to answer any questions. One other thing, yes. My client owns part of the property, and we are in a purchase agreement for the other part of the property, and the owner of the other piece of property has agreed to the application. So there's no question about that. Thank you.
Okay, what was your name again? Rebecca or Alyssa?
I'm Elisa, and Rebecca's here to answer any questions,
Okay,
but
so
I don't
she's not
think
going to speak?
No.
Okay. Thank you. Michael Henderson, John Emrani, Donna either Gooley or Cooley.
Hi, my name is John Emrani, and I oppose the appeal, mostly because of density. The project is consistent with the City of Los Angeles Small Lot Ordinance Design Guidelines and the Valley Village Specific Plan. It is compatible with the existing development in the area. It's actually a lot less dense than the multifamily, I should say. Because of the housing shortage in LA, I think the project will provide needed home ownership opportunities because there's definitely a shortage of newly built homes and condos because everyone's building apartments. So this small lot project would be a nice addition. The new home ownership will help support and strengthen local economy. People will be living there, not just renting, and this will bring a good sense of community to the area.
Thank you. Michael Henderson, not here. Donna Cooley. Donna? Yes. Brittany Chanel and Ann Hars. Welcome.
I am a 35-year resident of Valley Village, and this project is not in compliance with city code, and we're hoping you will approve the appeal. Thank you.
Thank you. Brittany Chanel, Ann Hars, Jen.
Hello, City Council members. My name is Brittany Chanel, and I've lived in Los Angeles for the past 10 years. My father worked for LA County as a probation officer for 30 years. I'm a graduate student at Loyola Marymount, and I'm currently doing my thesis documentary on gentrification in Los Angeles and the affordable housing crisis here in LA, which is why I'm here. Through my research and following the details of this specific case, I am appalled and quite disturbed at the injustices that are occurring here. We as the people elect you, and your number one job is to represent us. And with that, you should make decisions that are right and just for the people in the Los Angeles community. I am asking you to uphold this appeal and to not approve projects that are not in compliance. Thank you.
Thank you. Ann Hars, Jen, Hillary Steinberg.
Hi, my name is Ann Hars, and I'd just like to say that there are about a quarter of the 4 million people in Los Angeles are living below the poverty line. The poverty line is under $12,000 a year per person, $24,000 for a family of 4. The median rent in Los Angeles is $14,000 per year. So LA really doesn't need to destroy any more rent-stabilized housing in this city. Certainly not for developments that are luxury developments. This is clearly a luxury development that no one living there will be able to afford. The developers don't even own this property and are in a legal dispute, which I have right here. This is the lawsuit that Urban Blocks has filed against 2 elderly ladies in their 80s. You can see it if you'd like.
Great. Thank you. Jen? Somebody who signed up as Jen? Hillary Steinberg? Sylvie Shane and Bill Ormer. Welcome.
Good afternoon, members of the Plum Committee. Thank you for this opportunity. I'm here to ask you to approve the appeal that is before you. I am here to represent the community. You can talk about studies, you can talk about research, you could talk about planning, architecture, but I'm here to represent the people. I am on that street, in that community, several times a week visiting family members and friends, and I can tell you that this project is going to be is not going to have any benefit to the community. On the contrary, it's appalling to me that it was even approved in the first place. I wasn't aware that a private developer, could take over a street that is a public street, number one. I've heard it mentioned by the developers that that street is underused, and I can assure you that it is definitely not underused. Thank you.
Thank you. Sylvie Shane. Final speaker is Bill Ulmer. Welcome.
Good afternoon, Sylvie Shane. The last time I appealed before this esteemed body, I was the appellant on a project at 1850 Cherokee that garnered considerable public outcry and resulted in the filing of a lawsuit against the city for its failure to identify the cumulative loss of rent-stabilized housing units, a requirement under CEQA. Once again, the environmental review for this project is an MND that makes no mention of the loss of 13 rent-stabilized units, ranging in price from $575 to $1,200 a month. Under an MND, a project is required to offer mitigation measures, and LA CEQA Thresholds Guide provides the replacement of affordable units as one. It would be within the purview of this body to require, then, that the project replace those affordable units. Also, it provides as a measure the exceeding of statutory relocation benefits. So I think that in addition to all the issues that this project seems to have, the MND requires some mitigation. Thank you.
Thank you very much. Some quick questions on this. The issue was raised as to whether the applicant owned the property. Is that relevant or material to whether this application can continue? Either planning staff or city attorney, can you answer that?
Adrian Corsani, City Attorney's Office. So the question that's before you is actually the appeal on the vesting tentative track map, and there were some CEQA allegations, and that's the extent of the appeal. And the same thing happened at the APC. So the question that is not before you is the sufficiency of the application. Having said that, I don't know if planning staff wants to address the fact that before development can begin, ownership will have to be secured.
Yes. I've often wondered that. I want to go and title some property, and I'm just going to do it. I don't own it, so that's pretty... How do we handle that?
Commissioners, this is Kevin Jones, planner for the Valley Planning Offices. When applications are taken in, the applications do contain the signatures of the property owners and the applicant or representatives. So there should be some evidence in the case file that indicates that they were notified of this application, and that's what should have happened.
And do we have evidence of that in this case?
Yeah, we will have to review the case file for that.
Okay, so we don't know if the owner has... I would take it that the representative here could state in public that has been the case?
Councilmember Weezer, when we filed the application, yes, we had authorization letter from the other property owner.
Okay, so that is in file. You could attest to that here.
Yes, that should be in the file.
Okay, another issue is the Ellis Act, and we've had some cases here where we feel that the Housing Department is not speaking to the Planning Department when these cases come before us. We had some cases where some of the tenants were not provided their proper relocation assistance, nor did we know at this point in the game, yes, this is a separate application, but something that is of importance and of a priority to this council is that we abide by all the requirements of the Ellis Act. In this case, do we know whether the tenants have been given their proper relocation assistance? We don't know that, I figured, because we had the same issue last time where the Housing Department does not verify with the Planning Department whether we are entitling property or giving additional support to projects when they have not abided by other laws that we require them to abide by. So we don't know if they've abided by the Ellis Act here.
Councilman, based upon the information that is on the staff report and the findings number 7 on page 33 and 34, we make reference and we do rely on the professionalism of the Housing and Community Investment Department regarding compliance with this state rent stabilization and the Ellis Act as far as providing for relocation assistance and for whether or not the rent levels have been complied with and whether or not there have been any changes to that. So based upon the information from housing and our reliance upon the municipal codes, we are relying on that professional expertise to find that they do comply with the Ellis Act and the rent stabilization of the City of Los Angeles.
And what does that state there, that they have complied with it? Or it doesn't
It
say?
says, as stated above, the 9 units on the subject site are subject to the rent control provisions of the RSO. However, no units of the property have been specifically protected either by covenant or by other agreement or other city approval for use by very low or low-income households. Also, as stated above, the project will comply with all applicable state and city regulations regarding the removal of these rent-stabilized regulated units, including the payment of relocation assistance to any current tenants.
But we don't know if, in fact, that has happened, correct? There's no evidence of that in our records here.
We have no evidence of that, but we are relying upon the
okay.
professionalism of the Housing and Community Investment Department for that.
Yeah. Can I ask the applicants, what is the situation?
Yeah, hi, my name is Rebecca Duell. There are recorded documents with the county recorder removing those units from the housing market. It's public information and it should be in the file, and if not, we can add that.
Okay, but our question is, have the tenants who have lived there been provided the relocation assistance?
Yes, they've
under
been
the
paid.
city rules?
Yes, we've met all of the requirements per the Ellis Act, and they have been paid their due fees.
Okay. Cedillo, do you have a question or no? Okay. Mr. Cedillo.
You know, that sounds really shaky, perfunctory. There's two concerns here. One is this question of site control, and it seems to me that that's being challenged, and that there's an issue. There's some question and dispute about whether or not there's site control and whether or not they have the property. Now, we can say, all of us could say, well, it said that in the file, but it's been brought to our attention. We all sit here and somebody's come and made this claim that there's dispute over who owns the property, and so it would seem, I'd like to hear something a little more affirmative other than there was a letter in the file that said they owned the property. It seems to me that there should be something that's a little more substantive as the committee sits here to ponder whether or not we move this forward. We'd hate to move this forward, and at some point in the future somebody come back and say, well, they didn't really own the property, and now we've got a bigger problem on our hands, and our only reference is that somebody made a reference to a letter in a file. I'm listening.
We are not handling the lawsuit, so I cannot tell you a lot of the details of the lawsuit. What I can tell you is that my client and the owner of the other property entered into a purchase and sale agreement. There has been a dispute regarding one of the appellants about a right of first refusal to own that property. But at the time that we filed our application, we had the owner's permission to enter into that, to enter into the entitlements, and we still have that permission. That's what I can tell you.
Adrian Corsani, City Attorney's Office. Council members, if I could just reframe the issue. So what's before you is an appeal on the vesting tentative track map. Implications of CEQA were mentioned. The sufficiency of the application and the RSO is not before you, but the map is. So if you can make a determination on whether the findings were sufficient or whether they were insufficient, that is for your consideration, as well as whether or not you've heard a fair argument today.
Got you. Thank you. This is Mr. Sir, go ahead. Go ahead. Yes?
I have conformed copies of 2 face sheets that the developer filed. One is against the Edwards Trust, trying to force them to sell the property, and another one includes another person, Jennifer Getz. The lawsuits were filed on September 7th of this year. The first amended complaint was filed in October. It's very clear that if the developer is suing the people who own the property, that there is no agreement, and therefore he may not speak for them, and they are not here urging for this at all. So therefore there is no site control, and these documents have been submitted to the public record, and they're certified copies of the lawsuit.
Thank you, sir. Thank you. So what we will do is, I would request that we continue this item till next week and get an opinion from the city attorney's office as to whether the item before us, if the issue of ownership is a material issue that we should consider it. But secondly, I also would like additional information on the Alice Act and the rent stabilization ordinance for this committee to have before it some evidence whether or not tenants have been paid their relocation assistance, and we've complied with that. Understanding that that's not the issue before us is the Alice Act. However, we are in the process right now of correcting the deficiency within our own process in the city, where we have asked for that type of information to come before this committee whenever property is subject to it, and we need to have that information before us before we move on. It's a policy decision that we have. I know that's not the actual item before us. Yes, sir.
Councilman, you may want to instruct the housing department to come back with that information.
We could instruct the housing department to come back with that information. And any other questions we need answered before this comes back to us next week from anyone? No? Okay, we'll look forward to getting those two answers when we come back next week. We'll continue this item. Is there any deadline to act on this?
Yes, the deadline of the file is the 18th of November.
That's by council, it's not committee, right? So
Yeah, for council is the 9th.
Of November?
Yes.
Okay, so we have sufficient time here at next week,
Yeah.
and we'll have sufficient time to still schedule it if need be. Okay, thank you. Any objections to continuing this item? And with, pardon me? Okay, and we'll get those two answers back to us. Thank you. All right, what we will do now is we'll hold on to item 11, and we will move to items 12 and 13. I know there were a lot of folks here on this item. We apologize for the time it took to get to it. We actually didn't have PLUM last week, and we had